This course is Tribal Courts. My name is Michael Smith. I'm an adjunct professor at the University of Oklahoma Law School. I'm a practicing attorney. I practice in Norman. My office is down on Campus Corner. I'm a district judge for the Sac and Fox Nation. I'm a member of the Chickasaw Nation, and I also do contract work as a court advocate for the Chickasaw Nation. And we're going to be talking about the 6 doctrines that are used to define federal Indian law, and they give you a framework by which you can understand the cases that will be presented to you and put some clarity on how tribes got to where they're at today. Oklahoma's kind of unique because all of this plays 2 and 4 tribal nations in the state of Oklahoma. I know some of you are from other places around the country, but tribes arrive here all with a similar story, not the same story, but a similar story. And when they encounter the federal government as an active player, kind of determines what has happened to them. There are 6 doctrines of federal Indian law. It's the doctrine of discovery, the trust doctrine, the doctrine of plenary power, reserved rights doctrine, and the doctrine of implied repeals, doctrine of sovereign immunity. We're going to cover each one of those over a series of lectures, starting off with the discovery doctrine, because the discovery doctrine really leads us to an understanding for what seems to be almost nonsensical court rulings. They're all over the board, but once you understand these lenses that you're going to be focusing federal Indian law through, they're all explainable. The doctrine of discovery, we first, I say we, my sister and I began teaching this course some years ago. She has since passed, but she and I developed this curriculum, so occasionally you're going to hear me refer to we, and it's not the royal we, it's actually 2 people. But we got exposed to the doctrine of discovery at the Oklahoma Indian Law Symposium through Robert Miller. He wrote a book, that's this book right here, Native America Discovered and Conquered. And I'm going to be using, I use lots of different things. Now, our book that we're using for the course is Uneven Ground, and we've used it for some time. American Indian Sovereignty and Federal Law, written by David Wilkins and Tisanaya Lomawamia. I butchered that. Apologize to her. But it gives you that skeletal framework, and where other books have not, so that's the one that we try to use. More recently, and these are, I've got a couple of magazine articles here. One is from Parade magazine, the other one is from Time, and it is their note of what's happening at the top of the world. The countries that share the Arctic Circle are in a controversy because the polar cap is melting, and as a result, there's a shipping lane that's opening up above Canada. And it's going to cut 3,000 to 5,000 miles off of freight as it continues to shrink. It'll be open year-round, and ships will be able to pass through it. The article was called Fight at the Top of the World, and basically it's a discussion about how are we going to divvy up this enormous piece of international land. And some of that, it depends on who you ask whether or not it's international or not. Most of the countries view the land underneath the strait that's going to be opened up as part of the continental shelf, and that entitles them, according to international law, access to whatever resources that may be developed at the bottom of the ocean, not to mention the shipping lanes and the ports that will be open there as well. As soon as it got clear enough for access by ships, the Russians and the Sweden, got together and they developed a submarine that could go down to the bottom of the ocean, and there they planted a flag. Now, that's pretty odd behavior. It cost them a lot of money, and yet they went to the bottom of the ocean, planted their flag, came back, and staked that land out for Russia and Sweden, which are also up in that area. Since that time, Russia has continued to try to develop resources up there. The United States, of course, has their own view of how much of that territory should be theirs. It's thought that 25% of all natural gas and oil may be lying in this area that's going to be opened up. So, and time has passed. These articles are somewhat dated. 2008 probably is when they were originated. But one of the controversies was when they planted their flag, nations were going, now wait a minute, you can't just go and plant your flag there and claim this land to be yours under international law. They cited the fact that when the United States went to the moon, the first thing they did when they got out of the capsule was to plant a U.S. flag on the moon. And the Russians were quick to point out that just because you planted your flag there doesn't mean that you own the moon. And that's really kind of is what is at the base of the doctrine of discovery. It's an international law that was developed in the 1400s by papal bulls. There's a series of popes that stretch over a couple of hundred years that developed this theory. They claim to have jurisdiction in this area because by divine right, the Pope is the theological shepherd of all souls on the planet, ultimately, once they're converted. So they claim to have jurisdiction. Now, the European countries, which were at the time of discovery, which was in the late 1400s and throughout the 1500s and all the way up to the 1600s probably. The European countries, at the time that the law was developed, and it's an international law, at the time the law was developed, they were mostly Catholic. So the Pope was the arbiter of any disputes that might originate in the New World over land and resources and who owned what percentage of what space as they get to the New World. And you have to understand something that is diverse about our form of government, what might seem natural to us as to what is going on with European monarchs as they develop through this time frame. European monarchs are believed to be divinely selected. So they are picked from God. Their power comes from God to the person, from the person to the people. In the United States, the Constitution is about the people. All the power to rule comes from the bottom and goes up to the top. We allow you to rule, where the other one, we're getting this from God, so they can be more arbitrary in their rulings over their people. And because of that divine nature, that's why they look to the Pope to be the arbiter of these disputes when they got to the New World. So they decided they needed to come up with a way that we could determine as to which country controlled what area. They developed the doctrine of discovery as a way to figure out this kind of broad question. Initially, Spain got the largest swath of property rights in the New World. Portugal got into a dispute with Spain, and so the Pope drew a line, basically, on the globe as they believed it to be, and said, Spain, you get this part, and Portugal, you get this part. And when you go to South America, for instance, you'll see that Brazil speaks Portuguese, everybody else speaks Spanish. and that's because of that dividing line. But as time goes by, other European countries get into the discovery business. France, Great Britain, Holland, Spain plays a big role. And these countries all come to America, since we're talking about federal Indian law, or North America, and stake their claims. And the first thing they do, of course, is plant their flag. They come to a watershed, and they automatically have to let everyone know that they have arrived and they're staking this for their king or queen. And there are 10 elements. Like any law, the doctrine of discovery has elements that must be satisfied. And it's really a method for perfecting title to the lands, which is really a kind of a European model where land is scarce and owned mostly by the monarchs. So they had to have a method to let people know you can't just come and plant your flag. That's what was in the article, of course, and that's not enough. So there's 10 elements. So the first discoverer, they must put up markers to let other people know that they have discovered the land. They must have actual occupancy and current possession. And that's what kept Spain from owning most of the New World. They didn't have enough people, settlers, colonists, military, to occupy the great space that they were granted. So Great Britain came in later in the 1500s, and they staked their claim to much of North America. France came in through Canada and staked their claim. Spain was in the southwest, of course, as we all know, and some of Florida and in the Caribbean. And others came and selected their spots on the northeast shore. To determine what land it is that you're going to own, they had to figure out a device because the land is bigger than the place where you built your colony. So they went to the mouth of whatever fresh water that might be in the area, and that's where they would start their settlements or their colonies or their forts. And when you plant your flag, you build your fort, you establish your occupancy, you also are entitled to all of the land that is the watershed basin for that fresh water that's coming to the ocean. So on the northeast coast, there's lots of rivers and so forth feeding into the Atlantic. So the watersheds are small, generally speaking, and that's how you end up with 13 different colonies. But with France, who came from Canada and got on the Mississippi and went down to what is now New Orleans, well, that watershed is huge. It goes all the way to the Rocky Mountains and all the way to the Canadian border. So that piece of land is just enormous. Now, that brings up a topic that most of us learned, and we all kind of learn the same from the same textbooks. And I know I went to school a long time ago, but I have 4 kids, and they're 19 to 30, 29. And basically, their middle school history books were just like mine. And they described the doctrine of discovery with the same picture of Columbus jumping off the bow of the boat and driving the flag into the ground. And so they don't really tell us that those are just symbols of what the law really stands for. We recently went to Washington, D.C., and we were at the National Archives, and there was the Louisiana Purchase, which we're all familiar with. 1803 through 4, they purchased, Thomas Jefferson purchases, the United States purchases the land from Spain. Spain gets it from France. And right there on the document in a federal registered building is a general who says the best real estate deal in the history of the world, because they bought it for $15 million, and it's this enormous expanse of land right through the heartland of the country. But that's really not what it is. The doctrine of discovery, with its 10 elements: you must plant your flag to perfect your title, you must set up a colony, you must establish what your boundaries are for the land that you are claiming, and then if there's indigenous peoples there, you have the preemptive right to purchase their land if they choose to sell it. And here comes much of the debate that you're going to get into in federal Indian law: is what kind of title do Indian people have as a result of the discovery doctrine, this international law. Most of the philosophers of the time that it was developed kind of deferred to one Francisco de Victoria. Yeah. Francis de Victoria was a philosopher who was recognized by the church and by kings as kind of the preeminent intellect of the time, trying to determine what property rights indigenous peoples had in discovered lands. His article were Indians Discovered Lately, something along those lines. And he wrote that the indigenous people actually owned their land and developed it, did commerce on it, lived there, and had lived there for millennia. So they had property rights that existed under the doctrine of discovery. Now, the European countries, they all take kind of a different approach in trying to determine what an Aboriginal title may consist of. And that's really where the debate kind of gets going for federal Indian law. But they have the preemptive right to buy. So basically, once a discoverer comes, plants his flag, does all the things that are required, he has impaired the indigenous title, because they can only sell to the discovering party. All of the rest of the European nations have agreed that they will not try to buy land that has been discovered by a different sovereign. So the title becomes impaired. They only have one buyer, basically, for their land if they choose to sell. Now, there's a presumption that the buyer will give fair market value for the property that they are trying to get, but not all, when there's only one buyer, it's hard to determine what fair market value is. And so Indian title, or Aboriginal title, there's a lot of names for it, becomes quite a controversy and a debate as we roll forward through time. But tribes are believed to be sovereign over the land that they occupy, or indigenous people. And the continuity, that's how much land that you have according to the doctrine. And that goes back to the watershed issue. Terra nullius, that's a term that they use to, they said, well, since they're not Christian people, which is kind of part of this debate, because the Pope wants them to go out there and convert those peoples to Catholicism. So there's a religious component to all of this, which kind of speaks to the fact that they believe the indigenous people to be kind of in the dark while they're trying to bring them to an enlightened state. So terra nullius is a term that says land that is void of any kind of proper commerce or industry, not being used for a righteous purpose, or being used for a wrong purpose. And if that's the case, then we may go to a just war. And that's a term that's been used throughout history. President George Bush used it when they invaded Iraq. He said this will be a just war. And if you look up just war in the cases for federal law, Well, it's probably international law as well, but we have codified it here. There's a prosecution that must go on internationally if you're going to make war against a sovereign nation. And it's just like anyone else who's committed a crime. You have to serve notice on them. You have to let them know what the crime is. You have to ask for a change in behavior. And if you think about Iraq, they did all of those things, right? And then they went forward, and George Bush uses the term a just war, and it's straight out of the Doctrine of Discovery, which most of us probably had no idea that the Doctrine of Discovery is an international law that carries forward to modern time. So the edict from Rome was that you can do these things to perfect your title, and once you purchase the land from the indigenous tribe or people, you've now done all of the elements of the Doctrine of Discovery and have perfected your title, and now the title has transferred from them to you. There are the 10 elements that we just kind of loosely went over. Were first discovery, actual occupancy and current possession, preemptive European title, which is the impairment of the indigenous title, Indian title and how it's defined, and it's defined multiple ways depending upon the sovereign. Tribal limited sovereign and commercial rights. Really what most of the discovering nations wanted in the beginning was the right to do commerce with Indian tribes, and then the purchase of their land, because resources were scarce at the time of the discovery was going on in Europe. Continuity of land, that's based upon the watershed basin. Terra nullius, the land must be being used for a good, proper Christian commercial interest. Christianity, we want to spread the word of Christianity as a result. Civilization, they want to assimilate tribes into working, productive citizens of the world as they viewed it. And then, if none of that worked and you had indigenous people who refused to comply with the elements of discovery, there was conquest. And it could be military conquest, which gets back to the just war. But conquest also has a dual purpose. They also could do conquest legally without firing a shot. And that's what much of federal Indian law is about, because there really weren't very many Indian conflicts. I know that we romanticize that there were a lot of indigenous conflicts in the United States, but really I don't believe any war was ever declared against any tribe that I can think of at the moment. And so those are the 10 elements, and that's kind of the basis for the Doctrine of Discovery as an international law. Now, when you get to the United States, you have the 13 colonies on the eastern seaboard. The colonists were quite aware, because that's some of the issue that comes up when people talk about the Doctrine of Discovery as maybe a legal fiction. But in fact, the colonies, they were quite familiar with the Doctrine of Discovery. And so they were in constantly trying to acquire land from tribal people, but they had to do it with the permission of the sovereign, because only the sovereign can erase an aboriginal title. You can't buy tribal lands as an individual without permission. Your title will be no good, because under the international law, the only way that you can get title is through the sovereign, the discovering sovereign. So that created quite a industry in the colonies. They oftentimes did a number of things to try to acquire title. Sometimes they were fraudulent, sometimes they were fair, sometimes they were somewhere in between. And on the East Coast, the Indian tribes lived in close proximity to all of the colonists. So they were quite familiar. They lived among each other. So the tribes were familiar as well as the colonists were familiar with the doctrine of discovery. As time progresses, they take these discovery rights and they try to acquire property within their colonial boundaries. Great Britain, I think, did 175 treaties with tribal nations prior to losing control through the War of Independence. So the tribes were quite familiar with the treaty process and how to deal with sovereigns. That's just Great Britain. We had Spain and France and others. The others were kind of minor players, but those are three big players, and they probably had like numbers of treaties that were done with indigenous people. After the War of Independence, the colonies quickly moved to states, and the first order of business was to declare title to land that was not achieved with permission of the sovereign to be void. So they tried to void out all the titles of land that were not bought properly. And the interesting thing about that is each state had their own version of this process. And it was really kind of the primary, it was a major factor in developing a federal government. Who's going to be in charge of the discovery rights? If we went down that course, we would have 13 colonies with 13 states with 13 sets of laws directing the development of title to property, voiding of other titles, and some states chose to void all titles and start over fresh because, you know, land is probably the only commodity in the New World that has tremendous value. We weren't taxing at the time, so they had to have ways to generate revenue. Much of the debate of the Continental Congress was about unifying the ability to acquire land from indigenous people, tribal people. And they finally won out on that decision because the tribes also, and some of them were big and powerful at the time, wanted not to negotiate with multiple parties. They wanted one central party that they could negotiate with, and eventually all the colonies came aboard with transferring those discovery rights or allowing the discovery rights to be recognized at a federal level. And so that required them to put something normally in their constitutions that said that they had no right over Indian lands or Indian peoples or ability to tax, something like that. Those are called disclaimer clauses. And the federal government then acquired that discovery right, so when they signed the treaty in Paris and they got from the discovering nation, which Great Britain had consolidated much of the discovery rights of the other sovereigns. Now, Spain was in a different place in the United States, so Great Britain didn't really have to address this issue with Spain, but got into a conflict with France over these very issues about the land from the Mississippi River to the Allegheny and Appalachian Mountains. And eventually, France ceded their discovery rights to Great Britain for this area. Now, Great Britain, prior to the War of Independence, believed they had all the coast. Then after the independence in 1812, they acquire from the Mississippi to the mountain ridge. Those discovery rights transferred to the United States. Now, the United States had to decide what kind of discovery rights are we going to use, because different sovereigns use different principles of discovery. The original international law required preemptive title, which means that you could only acquire and perfect your title if the tribal nation agreed to sell it to you. as time goes by, other forms of this discovery right come into play. There's the absolute, which is once the Christian discoverer plants his flag, establishes his colonies, establishes trade, that the Indian Aboriginal title no longer exists, and they can be swept away with whatever means that are available to the discovering sovereign. And then the expansive is somewhat similar. It says that, in fact, we're going to allow you to be tenants on your land, but the actual owner of the land would be the discovering sovereign. So that's not, but from a practical matter, that's not how history developed. All of the sovereigns in America, in North America, they used the preemptive method. I don't believe I can think of an instance right off the top of my head where they did not try to acquire sovereign land from a tribal nation without purchasing it. And that brings us back to the Louisiana Purchase. Because really what we're looking for is what kind of evidence is there that the discovery doctrine is still a valid law and is used by the United States in dealing with tribal nations. You'll find verbiage from the elements of the discovery doctrine in the Constitution. Thomas Jefferson, the colonists already knew how to acquire land from indigenous peoples. Thomas Jefferson, when he does the purchase, the Louisiana Purchase for $15 million, knows the first thing that he has to do once he's acquired it is to establish the United States in Louisiana and New Orleans. And what he got for his $15 million, now some of the title had been perfected, right, by France, who started New Orleans as a trade center and established towns, forts, settlers along the Mississippi. When they deeded it or ceded it by treaty to Spain, then Spain acquired title, and they probably perfected some titles as well. But this is a small part, only around the mouth of the Mississippi. So when the United States acquires the Louisiana Purchase, what did they acquire? Well, they acquired the right to try to perfect their title for that large swath of land that runs from the Rockies, from the Continental Divide, all the way up to Canada and flowing back to the Northwest. And at the time, they did not even know how big the watershed was. So the first thing they had to do was establish someone to go out, survey the land, and let the tribal nations know that there's a new sovereign. And their dealings will now be with the United States because they have acquired the doctrine of discovery rights from Great Britain, who's accumulated them, and then from Spain, who accumulated them from France. So they sent Lewis and Clark out up the river towards the Northwest to kind of let the tribes know who the new sovereign was, to survey, because that is the perfection that they needed to do immediately to maintain their sovereign rights over this discovered land, so that others would not try to infiltrate, and because you have to occupy. That's a big piece of land to occupy, and so far we're not occupying it. So we had to do as best we could to try to make sure that other sovereigns knew that this is ours and you must stay out. So we paid $15 million for the discovery rights from Spain. And just as a point of reference, because we're going to read some cases in a few minutes about those three types of discovery acquiring of title: absolute, expansive, and preemptive. We paid $15 million for the discovery rights from Spain. We paid $300 million to the tribes for the acquiring of their homelands and their sovereign land that they had lived on for millennia. So if it were true that it was absolute, we could just brush them away, we wouldn't have to pay anything. And in a few minutes we're going to read a case, Johnson v. McIntosh, it's where all of the doctrine of discovery begins for federal Indian law, where they kind of define what kind of federal discovery rights that we have. And that case leans towards expansive, which means that the tribes are just tenants on the land, and they can be removed by the landlord at any time for whatever reason. Now, that doesn't prove out to be what history has told us, right? The discovering nations acquired title through their preemptive right. The colonies acquired title through their preemptive right. When they became states, they codified those preemptive rights into law. When the federal government came online, they could have just tried to push the tribes away, but they didn't. They treated with the tribes and tried to get land that way, and that was the way they perfected their title. And then we have what was going on though in the states after we sign on to the Constitution. States began to have trouble with their citizens trying to acquire Indian land. So states set up land brokers who would go out, and they gave them the authority, right, to go out and not purchase the land, but to sell Indian land, so a future interest in tribal property. And they would sell it all over the place and resell it. It was like a commodities trading that was going on. And then once the federal government would come in and perfect their title, then these future interests would come into play, and these people, whoever had title at that point, could acquire their land. They've already paid for it. They've already done the things that they need to in the state to become landowners. New York refused to honor their commitment to the federal government, and they began to treat as a state with Indian tribes in their area and also acquire land. That became a real problem, and that brought us around to a series of cases that reached the Supreme Court to kind of define from a federal level how we're going to deal with these issues. And so in the next lecture, we're going to go over 5 cases briefly that will demonstrate the different views of the doctrine of discovery.